If you are a law student dealing on criminal law, believe me when I tell you, there is no better way to succeed 300 level or succeed criminal law than to master element of crime. Element of crime is the fulcrum, the ground norm if you like, upon which criminal law is built upon. Be it in first semester or whether on second semester, everything that you must prove as a criminal law student in your problem question, in your essay question, is that there must be an actus reus or a mens rea established for there to be a crime, except in the event of strict liability. So this is what we are going to do today on the criminal law lecture class. This should be our part 4 video on criminal law lecture. We started with the first part, the nature of criminal law. We then attended to element of crime. From there, we proceeded to intention. And today we have come to discuss again the follow-up aspect of mens rea. That is the follow-up types of mens rea. I have told you people that for there to be a crime, it's not just enough that Okike is dead. It's just not enough that Taiwo is being raped or Ahmed is being killed. You must show some certain things. You must prove some certain things apart from the physical element all eyes can see for you to establish a crime. And believe me, by the end of this video, by God's grace, by Allah mighty help, you are going to see in real time how this thing works. And I'm going to give you more further cases to illustrate this as we delve into the further aspect of mens rea. If this is the first time, the young boy you are seeing here is going by the name Kingsley Omeyi Ifeanyi Chukwu, better addressed as King's Advocate. I'm currently, as at the time I made this video, in my 400 level. And what I do on this channel is to help law students to meet up with the challenges of being tomorrow lawyer. Law can be challenging, law can be complex, and that is why we created this channel, to assist everybody to achieve their potential, to be an added voice to our lecturer, to make the path smooth for both fellow law students and lecturers. In case you are interested in receiving video notification, most often on Friday, Saturday, and Wednesday, I encourage you to subscribe, not because it pays me by you subscribing, but because it will help you that whenever we make a video, you will be among the people that will receive it. Who knows whether that one will help to alleviate your pain. So without further ado, let's dive into it. I will also encourage you to like the video. This is me repeating it once again. Always like the video whenever you see our video. It goes a long way. And now, to my dear future lawyers, we discussed types of mens rea, and I told you people that types of mens rea or aspect of mens rea basically boils down to the fact that for you to convict somebody, you must prove the actus reus, that is the physical element. Then you must go further to prove the what? The mental element. Then under mental elements, we have intention, we have recklessness, then we have negligence. These are the things that are what? Embedded under mens rea. So intention, as I defined in my last video, by the way, please don't panic, because it seems like you jump into secondary school without passing primary school. But if you can still follow this one, go on. If you cannot, in this description, there are videos lined up as I'm talking. Video I posted on this topic is lined up. You can start from there. But if you can follow this one up, just follow it up. At the end, I will still going to link you with the link you are going to watch. We are together. Just pay attention and you will understand everything. So you have two choices. Go to the description box or the channel, check this video on criminal law playlist, or continue with this one. At the end, I will still show you where you are going to find the video. So intention, as we defined in our previous video, is a volitional act coupled with the surrounding knowledge and then the desire to achieve it. Let me just take this away from this kind of English. Intention simply means a voluntary act, then coupled with the knowledge of the surrounding circumstances of that act which you are aware of, and you still goes ahead with that desire to achieve it. I gave you people example of a woman who basically, because of her child was hungry, and then decided to steal a loaf of bread. So stealing a loaf of bread in this case, her motive rather, was to feed what? Her baby. This is motive. But then her intention was what? To steal the bread. So this is what I led as an evidence or as an example to clarify the difference between intention and motive. What I'm trying to say is that whenever we are talking about intention, please don't misplace it with motive. Under the general principles of law is that intention is relevant. in criminal law. Without intention, you cannot convict any person of any crime. On the other hand, motive is irrelevant except where the law declares it to be. Consider your section 24. So the motive of you stealing a bread to aid your daughter or to aid your son in order to eat cannot be a justification for you not to be held capable of being, stealing a property or held responsible for stealing. Are you getting me? But the intention now is to steal. So if you have formed that intention to steal, in this case is voluntary. Remember our definition. You are now formed the intention is voluntary act of stealing. Then the surrounding circumstances is that now you are aware that stealing here, what you're about to do now is you are about taking another man's property, which is a crime. Already you should know. You cannot deny it that you don't know. After all, section 22 of the CC say that ignorance of the law is not an excuse. So no man don't know that stealing is a sin or is a crime. So this one, this is the surrounding knowledge, you are aware, and then backed up with the desire to achieve it. So for there to be intention, there must be a voluntary act. You must not be forced to do it. If you are forced, it is no longer your intention. Are you getting me? It's become another crime altogether. There must be intention, voluntary. There must be surrounding knowledge. You must be aware of what you are doing. Then third, it must be backed up. Awareness is not enough. It must be backed up with desire to achieve it. So you then went ahead to steal the bread, and then they have come for you, and then you decide to say that you didn't have the intention. From there, you move to motive and say that after all, I was stealing it to, aid my daughter, to aid my son. But now, in as much as section 24 made us to understand that intention, motive is irrelevant. Motives has weight when it has to do with what? Typically in criminal law, motives has weight when it has to do with sentencing and punishment. That is when you see motive with having weight, because the judge, if judge is left with the discretion to give 10 or 15, he may choose to give 10 instead of the full punishment because of, you are stealing to help your baby and all those things. But as far as holding you responsible is concerned, motive is irrelevant. That will then lead me to what we have come here to do, which is what? Aspect of Mens Rea. And I told you people that aspect of Mens Rea means types of what in Mens Rea. That is to say, what are those things that are under Mens Rea? And I told you intention, I've defined intention, clarified intention for you, both here and in the previous video. Now I'm telling you other aspect, which is recklessness. What is recklessness? The reason why I say this is because intention is different from recklessness. I will still tell you people the effect of recklessness as opposed to the effect of intention as that of negligence. Why I will proceed. Please, if you have not liked this video, I beg you once again, like the video. I have told you that liking the video will help it to be relevant on the YouTube. Please like. Oh, thank you. Recklessness means consciously taking an unjustifiable risk despite being aware of it. The person does not desire the consequence, but takes the risk anyway. I repeat myself. Recklessness means consciously taking an unjustifiable risk despite being aware of it. The person who is doing it does not desire the consequence, but take the risk anyway. You see recklessness most often whereby somebody is driving on the road. The person don't intend to kill anybody. He don't intend to harm anybody. But he's aware that driving recklessly or driving fast in this kind of, even not in a highway, driving so reckless could lead to death of a person. He's not willing to kill, but he's still driving. What is he intending to? He's being reckless. Will he be exempted if he kills somebody? The question before this honorable court, because most often this issue of intention will arise when the defense, when the person acknowledges that he has done that, but he didn't have the intention to do it. Especially lawyers now, trust them. This is always where they try to exempt the person from criminal liability. This is where we are even called liars in the first place, because a dead body will be there in the coffee, and the lawyer will be arguing and telling the court that the person didn't plan to kill. If you didn't plan to kill, what then did you do? So in the case of R against Cunningham, remember I told you that we have come to analyze and use cases. We don't analyze based on assumption. Not my word. It's the word of the law. So we must follow it from the law. So in case of R against Cunningham, Lord Bryan stated that a person is reckless. Mind this word. Lord Bryan stated that a person is reckless if they foresee a risk that their action could cause harm and still proceed. So you are reckless when you have seen that there is something that could happen for me driving like this, under alcohol, under whatever, and I'm still driving. You can see some boyfriend and girlfriend kissing themselves while they are driving. What else are they hoping for if not to kill anybody? You may not have foreseen killing, but you doing that thing, common sense should tell you that you're on the highway and they are busy kissing. What do you think would happen, assuming anything goes wrong? This is act of recklessness, and the law doesn't expect people for being reckless. In that case, the court held that a defendant could be guilty even if they did not foresee the risk, provided it was obvious to a reasonable person. Remember what I told you in our last video, that most often the decision in intention Mens Rea is always conflicting. Remember the first R against Cunningham said that the person must have foreseen it. You must have foreseen that like you are driving recklessly. You didn't intend to kill, but you must have foreseen that anything can happen and you could kill somebody. Then in this case of R against Caldwell, it's telling you that even if you didn't foresee, but if a reasonable man that eats or drank 9 months breastfeeding can deduce that you being or behaving this way will cause harm, that person will be imputed to you, because a reasonable person in your shoe should not have behaved that way, should not have driven that way, should not have, done as way you behave. So it's not about you, it's about a reasonable man. And of course, now many people are not reasonable, not in Africa. In the further case of R against Lamb, the court held that recklessness involved a gross disregard of surrounding risks. It's all boiled down to what you have been saying. And the perfect example I could use to give you is what? Driving. Because this is where recklessness is obvious. It could also be, what example will I give you when it has to do with murder now? Of course, as a policeman, you are holding your gun on the way. And then, you are just holding your gun. Ordinarily, you are carrying a gun. This was in Amayo and the state. You are carrying a gun. Gun should not be something that will tamper with. Then, unfortunately, you are in checkpoint. You are carrying a gun. You are intimidating people. And before you know it, you pull the trigger. And then somebody died on the process. You come to argue that you didn't intend to kill. You were reckless with the gun, and if it has been established that you were reckless with the gun, you are going in for it. Now, let me just clarify something. The difference, once you are convicted based on the fact that you had intention, you have killed somebody. Remember, we use killing most often because killing is the only way to illustrate this thing. Not that intention applies to all crime, except in a certain circumstance where the law exempts it, like strict liability. So we are using killing because killing is most obvious. So assuming now you have been convicted, you have killed somebody, you have proven intention, you are going in for murder. But if then it becomes recklessness and give rise to recklessness, most often you'll be charged, you'll be convicted for manslaughter because there was absence of intention. But then absence of intention, like let's see it this way, intention is here and then recklessness is here. So if it fell from intention, if your lawyer successfully saved you from intention, it could fall under recklessness. And then if it is under recklessness, the court is not exempting you. You are going for manslaughter. Manslaughter, the punishment provided is what? Life imprisonment at utmost. But the court, most often based on the criminal law cases I've read through my year 3, has always been what? They give 15 years, they give 20 years, some even give 3 years. So that one is discretionary. Once it's murder, you must be sentenced to what? Death. Are you getting the point? So this is how it works. But recklessness will often give rise to what? Manslaughter. You will still see it when we shall discuss on section 24 of the criminal code. And now let's talk about negligence. Intention is here, recklessness here, negligence is here. Negligence is the failure to exercise a reasonable care, then resulting to unintended consequence or risk or problem. So let me take it again. Negligence is unintended act which arose out of your own uncarefulness.
Law confusing? Let's make it simple. At lawmadesimpleLegal.com, we break down the hardest legal concepts into easy-to-understand lessons. Whether you're a student, lawyer, or just curious, you'll find clear explanations and real case analyses across fields like criminal law, contract, tort, and constitutional law. This is where law becomes easy and practical. This platform was created by Kingsley Omenyi, simplifying the law for Nigerians and beyond. Visit lawmadesimpleLegal.com or simply scan us on Google to discover how easy law can be.
So when you're talking about negligence, you are talking about the fact that you fail to exercise a reasonable care, which somebody in your shoe could have exercised. Therefore, it led to unintended consequence. You see this thing most often in medical world, whereby the nurse, of course, nurse and doctor are treated just like lawyers. They are treated with respect and honor because they are handling with people's life. The difference between them is that they are battling with people's life, and we are battling with people's freedom. That is one. Our own mistake could be exempted, at least. The only thing it will cause is to sentence you to. It's almost the same thing, but our own, most often it could be life imprisonment, but their own is automatic death. So imagine now, and our own can be remedied. Because even if a first court judge and lawyer were restless, Court of Appeal could do something, Supreme Court could do something. But their own is that once death is occurred, nowhere. So you see most often doctors are negligent. They can use injection B to took injection C, and they can mix things up, and the only thing they will just come. Just African magic now. We lost him. Take heart. Otilo. Before you know it, he's gone from the hospital. Before you know it, the nurse is just pressing his phone and viewing status when somebody's life is gone. You can't interrogate them. You don't know what they did. Most 99% of life that occurs in Africa, deaths that occurs in Africa, they are not God planned. Forget this thing, they will tell you Uche Chukwu Emego is God wish. Which God wish? Most of them are caused by negligence of doctors and medical practitioners. So this one is when you fail to do something. You didn't intend to kill anybody. You didn't plan to kill anybody. You weren't even reckless, but you failed to exercise the reasonable care. Recklessness is more of acting in nature, but negligence tends to be more of omission. Are you getting the difference? Recklessness is proactive. You are taking the necessary step to occasion something. But negligence is more of withdrawal. You are failing to do you are failing to take step a reasonable person should have taken if he was in your shoe. And then death occur, and then harm occur, and then something happened. Would the court exempt you? No, because it's still formed. When you cannot show that you intended, when reckless cannot be shown, the next question the court is going to ask is, were you negligent? Except where negligence is exempted under the criminal code and penal code. Once you commit negligence, you have penalty for it. Are you getting me? Once you commit negligence, apart from being torturous, because negligence is a torturous claim altogether, by virtue of law of torts. If you are still going to treat it first semester, I shall make a video on that. But even in criminal law, negligence is punishable because the law is using. Remember, the prime purpose of criminal law is deterrence. So, in absence of intention, recklessness, the court will always capitalize on what? Negligence as a mode of deterring the public from, exempting themselves from criminal liability on the ground that I didn't know, I didn't do it, all those things, I didn't plan it. Do you understand how this thing works? Why reckless involve a conscious risk taking? Negligence involve unconscious or careless disregard of the risk. Please take this away. Why reckless involves conscious? Reckless is that you are taking proactive, as I explained, risk taking. Negligence involve unconscious or careless disregard. You are not even aware. Negligence is more of subtle. It's just absence of your intellect as a reasonable man. That is what gives rise to negligence. And then, negligence is not primarily a criminal law concept, as I discussed. It's more often a tortious principle established in Donoghue and Stevenson, in Locus Classicus, that established the thought of negligence for the first time. So, but then, criminal law has taken note of it. So, it may give rise to criminal liability where necessary. Especially where, your act results to death and injury. You may be free from other, but once it has to do with death and injury, you cannot go away based on the fact that you were negligent. So now, with this, you will see that once the problem question comes, your ability to identify when the person was reckless, when the person was negligent, and when the person was what? Intentional about his act is what will give you leverage. Are you getting me in the law? So you must know when the person is reckless, acting recklessly. You must know when the person is negligent. You must know when the person is intentional. So once a crime has been proven to exist by virtue of actus reus, the physical aspect we can see, the next thing the court must always do is to turn to the intention of the maker. Because the general principles of law is that no person shall be convicted on a crime he didn't intend, that occur outside his own will, that occur outside his own desire, that occur by mistake. Mistake in this sense is not your normal mistake. Mistake in law is different from your regular mistake. So assuming now you are holding a gun and you want to shoot Mr. B and then you shoot Mr. A, you can't say it was a mistake. That mistake is for normal man. For legally speaking, see, my eye is paining me. My eye is paining me. All for you. And after I'll be begging you to like the video. So I just pray my eye will allow me to finish this video. So assuming now somebody have shot another person and then you'll be claiming and saying that it was a mistake. Which mistake? Mistake in law is different. Mistake in law is more often has to do with something that occur at the independent of your will, which I'm going to discuss in full when we come to section 24 of the criminal code. So I believe that this video helped you. However, one thing I'm encouraging you to do is, in case if you are missing some of this video we have made, kindly click the playlist above and you will go there and see further videos starting from the nature down to this second one, which is part 4, and then see how it's helping you. In the next video, I'm going to take my time to explain section 24 for you. I encourage you also to share. Please share to your class group, share to your growth group, because this is the only way I know we can help each other to grow. I honestly, I'm a participant to this journey, and I believe you help others make their life better by sharing this video. So I will see you in those videos.